starting this late. May I use this opportunity to also acknowledge the head of state, President Zuma, and also acknowledge the Chief Justice, and also acknowledge the Deputy Chief Justice and the Deputy President, and acknowledge the executive delegation, the ministers and the deputy ministers, and also acknowledge the judges. The President will read out the statement. May I also request your cooperation? I will allow only 4 questions, and if you just assist me in making sure that we only take 4 questions, given that it's so late, but it's over to you, President.
Thank you very much, Pumla. I'm not sure whether when the executive and the Chief Justice and the judges have been working so hard, we should apologize for working hard? Should we? I don't think so. Yeah, I think we've been working very hard. I thank you very much for the opportunity. Deputy President, Chief Justice, esteemed members of the National Executive and the Judiciary, ladies and gentlemen of the media, fellow South Africans, today I chaired the meeting of the National Executive and the Judiciary in my capacity as head of state. The meeting had been convened at the request of the Chief Justice, Mogoeng. The meeting took place at the Union Buildings in Pretoria to discuss matters of mutual concern directed at enhancing the working relations between these 2 arms of the state. We acknowledge the historic nature of this meeting, which is the first of its kind in our democracy. The meeting has contributed to the strengthening of our constitutional democracy. It is our conviction that such interactions can only advance and deepen our constitutional democracy. The Chief Justice had requested the meeting in order to discuss matters of concern to the judiciary. These included public utterances attributed to, among others, some members of the National Executive. The meeting was characterized by a frank and cordial exchange of views conducted in an atmosphere of mutual respect. The 2 delegations raised their concerns on a number of issues, including statements made in the public domain from both sides, which may have brought into question the integrity of both the National Executive and the Judiciary. The meeting took place against the backdrop of significant progress we have made as a country in the past 21 years of our constitutional democracy. The judiciary and the executive each reaffirmed their commitment to the independence of the judiciary, the rule of law, and the separation of powers, all of which underscore our constitutional democracy. We also reiterated our commitment to the institutional integrity of all arms of the state, the executive, judiciary, and the legislature. The meeting agreed on the following. One, our respect for the separation of powers and the integrity of the two institutions. Two, to exercise care and caution with regards to public statements and pronouncements criticizing one another. Failure to do so will undermine the global status of the Republic as a bastion of democracy, tolerance, human rights, and the rule of law. We should strive to promote the values and ethos of our Constitution in our utterances. The arms of the state should not be seen to be antagonistic towards one another in public. 3, the transformation of the judiciary and the legal profession are at the heart of our constitutional enterprise, and the parties have a responsibility to strive towards its achievement. 4, in those instances where judges are believed to have conducted themselves unethically and other arms of the state, entities or members of the public should make use of the structures set up to address such concerns and report them to Judicial Conduct Committee of the Judicial Service Commission. Similarly, complaints against magistrates must be reported to the Magistrates Commission. 5, all have duty to protect and promote the Constitution of the Republic to all citizens as the supreme law of the land. 6, court orders should be respected and complied with. 7, we reaffirm our obligation to the people of South Africa and to promote access to justice. We also underscore our responsibility to the people of South Africa to uphold the Constitution of the Republic. 8, this meeting is the foundation of future engagements to discuss issues that may arise from time to time. 9, the administration of the courts, access to justice, and transformation have been identified as issues requiring specific focus in future engagements. This historic meeting has yielded positive outcomes. It will enable us to work better together to serve the people of South Africa as independent arms of the same state. Serving the people is our shared obligation and commitment. The delegations were constituted as follows, presided over by the President of the Republic. From the National Executive was Deputy President Cyril Ramaphosa, Minister of Justice and Correctional Services, Advocate Michael Masuta, Minister of Science and Technology, Ms. Naledi Pandor, Minister of Human Settlement, Ms. Lindy Wesisulu, Minister of Environmental Affairs, Ms. Edna Molewa, Deputy Minister of Justice, Mr. John Jeffrey, Deputy Minister of Cooperative Governance and Traditional Affairs, Mr. Andres Nel. On the judiciary side, it was the Chief Justice Mkhweng, Deputy Chief Justice Tikhang Moseneke, President Lex Mpati, Supreme Court of Appeal, Justice Mohammed Solomon, Navsa, Supreme Court of Appeal, Judge President John Hlope, Western Cape, Judge President Diale Khomo, Free State, Judge President Monica Liu, Northwest, Judge President Dunstan Mlambo, Gauteng. I thank you very much indeed for the opportunity, and I would like the Chief Justice to add a word or two before the question.
Mr. President, Deputy President Cyril Ramaphosa, Deputy Chief Justice Tikhang Moseneke, esteemed members of both the executive and the judiciary, ladies and gentlemen, I greet you. I seize this opportunity, first of all, just to express appreciation on behalf of my colleagues in the judiciary to the President and his cabinet colleagues for having acceded to our request that we have this epoch-making meeting. I confirm the statement read out by the President as being a true reflection of the undertakings that we collectively made as we move forward towards making South Africa a better constitutional democracy for all of our people. I reiterate that it was indeed an eye-opener, an enriching exercise that can only bode well for both the executive, the judiciary, the legislature, and the entire populace of South Africa. And finally, I just want to, apart from correcting that we made a mistake, Judge President Diale Khomo is of the Northern Cape Division of the High Court, not Free State. We made a mistake. I just want to reaffirm our collective commitment as the judiciary to executing our constitutional mandate only in a manner required of us by the Constitution and the law, other than that, I can only reiterate my gratitude to you, Mr. President, for the fruitful engagement that we have had. I thank you.
Thank you. Thank you very much.
Thank you. I'll take question. Let me start with you.
Thank you very much, Ms. Williams. My name is Tsepo Ikane from the South African Broadcasting Corporation. To both President Zuma and Chief Justice, one of the reasons that has been advanced by those who have been seen as attacking the judiciary is that there's slow pace of transformation. And there's this also popular view that there seems to be, when judges dispense the law or judgments, there seems to be that is applied to the less privileged, and those who are privileged, those who have money, have a way to find it, to have a favorable kind of judgment. So that is the discourse that is out there. Is there an issue that is of major concern to both the executive and the judiciary? Thank you.
Karen.
Karen Morn, ENCA. I would just like to ask President Zuma, you have spoken about the mechanisms available for members of the public who wish to lay complaints against judges, which is the Judicial Service Commission. But there hasn't been any kind of indication of what action there is when judges experience ad hominem attacks, which are very generalized, non-specific, and have been attributed to members of your executive, insinuating that they are in fact taking bribes or making biased decisions. What mechanisms are available when those kind of attacks are made on judges? And will some kind of action be taken when attacks on the judiciary are unfair and directed in a very insulting way? Thank you.
Okay. The first question relates to the access to the law or many other things going with it to those who are poor, who don't have means or whatever. What was our attitude to that? The matter was discussed, was raised as one of the issues that was raised, and we have agreed that we should look into that matter. It's quite a matter that is not easy to deal with. I think there is a lot that is being done from the judiciary to say how do we handle those kind of matters, and the judiciary made that kind of point quite clear when we're saying how do we guarantee that there is equality before the law? How do we guarantee that when somebody doesn't have a lawyer, automatically that person is guilty, probably in one form or the other? So it's a matter that we have raised, we have discussed, we have agreed is a matter that needs to be looked at as you go forward. Because it is important that we must be seen as a country to be practicing our constitutions and rights, not in a lopsided way, but in a manner that makes all citizens feel the law is indeed treating them equally. I think we are a young democracy. We are moving forward. I think this very meeting, why we say it is historic, is because such matters could become to prominence instead of being taken step by step, perhaps in a lower pace kind of thing. That these are the matters because they relate to the citizens. And these are the matters I think we all agreed are matters that need our attentions. Before the Chief Justice come, let me also take the second question. Well, there is, even if it is not like a structure or in a sense, there is always an interaction between the Chief Justice and the State President on matters wherever they come. I don't think we've reached the point that if such things happened or people in the executive or politicians made utterances, what is the mechanism, as we indicated the mechanism with regard to people who want to complain. We did not necessarily say here is a mechanism. I think we relied on the interaction that is there. Perhaps the question is saying to us, we needed to have such a mechanism where you could go if that happened. But of course, this is taken really with the point that this should not happen. I think that was our agreement. This should not happen that people should find it easy just to criticize without specifics, without saying these are the specific issues that we think should be raised. From our point of view, the interactions we are talking about and engagement, we believe that if such things happen, we will have a way of engaging. But I can see your question when you say if the judge feels offended and he wants to raise the issue, where to? I think if, for example, the executive has done so, I think through, at the moment, before the mechanism, through the Chief Justice, I think those complaints could be channeled and we could find a way to attend to those issues. Perhaps the Chief Justice could throw a better light as a judge.
Thank you, Mr. President. To Mr. Tsepoikane's questions, beginning with transformation. Quite frankly, I'm yet to come across anybody who has spoken as much about the need for transformation at the level of the organized profession, as well as the judiciary, as much as I have. And I say it with all sense of humility. I've articulated that issue, outlining what could be done to accelerate that process to the point of risking impeachment. Some of you might have forgotten, but you have probably written some articles about that. And practical steps have been taken by the judiciary in that regard. The process or the project of accelerating the previously disadvantaged women in particular through the South African Judicial Education Institute program of aspirant judges is one of those measures. The mentorship programs that judges presidents have embarked on, as a result of which, even if you're not acting as a woman or as a previously disadvantaged person, you're allowed to act in preparation for the possibility of your elevation to the bench. Some of the champions of that process are here. Judge President Mlambo, Judge President Khomo, Judge President Monica Leo. When I was Judge President, there wasn't any court in this country that was as gender representative as the one in which I was serving. So we're continuing where we have been all along. But we have agreed with the executive that there is so much more that we can do. Maybe I should avoid together to avoid looking like I'm sounding your slogan, Mr. President. But there is so much more on a very serious note that we can do together. Every arm of the state playing its role, big business and state-funded organizations playing their role to advance the transformation agenda and take it forward. Access to justice, the rich versus the poor, you'll always have that problem in any area of life you can think of. A better resourced person will always have access to the best of tenders, for instance, or contracts, as opposed to the person who doesn't have access, by reason of not having resources, to the best of consultants to enable him or her to make a more attractive and persuasive presentation. But let me not look like I'm being defensive. What have we done? You would be surprised to learn, taking it at the highest level at the Constitutional Court, that we've had a number of people who approach us completely unrepresented. What do? We take it upon ourselves as a matter of course, even if their papers don't make sense to us, to invite public litigation centers, to invite the attorneys through their pro bono system, and the General Counsel of the bar through their advocates, to see what they can do to assist the poor and unrepresented, just so that there is some measure of parity in the manner in which their cases are advanced. But we have also, in circumstances where people are not represented, but you can make absolute sense out of their papers, entertained their arguments. There was a stage when the President's State of the Nation address was sought to be stopped by a man from Soweto who wanted Soweto to be a separate municipality from Johannesburg. I think Mr. Mutwening or Mr. Mutupe. We entertained his case. It's a matter of record. And entertained it well until he congratulated us at the end of his argument. Why? Because we've scanned the environment internationally. Some of us present here watched in Washington, D.C. as a second-year engineering student, was running circles around an attorney and ended up winning a case because of the flexibility of the rules that makes it possible for a person who is not a lawyer to understand what is required of him or her to prosecute his or her case. And that is why one of the measures to facilitate access to justice that we have identified is the overhauling of the rules. And I believe that the process identified by the President, through which there would be further engagement, will allow both the executive and the judiciary to put their heads together and explore the manner in which we can qualitatively and yet expeditiously embark on the process of rulemaking, so that they do not become so complex that even some judges find it difficult to understand what they mean. So, finally, on this point, judges and magistrates, as a matter of law that is available in our case law, go out of their way, because the guidelines are there, to assist the unrepresented litigants. That is the law. You don't represent them, but you go out of your way to ensure that their case is properly put across. And I believe the engagement, the future engagement of the kind alluded to in the President's statement will enable all of us to identify that these measures are in place, they have been applied, there are exceptions, as is the case in respect of each and everything, but then look for what else we can do to improve on the progress already made. The other question, Mr. President, from Karen Mona, I understood it to be yours, so maybe I shouldn't go there unless, the President has asked me that I touch on it.
It would be good if you went.
All right. Thank you, Mr. President. That we have come together as a result of statements that are critical of the judiciary in the manner they go about their business, or even also in relation to the public statements they make, is a positive step forward towards identifying measures that we might not have been taking in the past. To zoom in on a text of this nature before further ado, when they arise in the future. Today's meeting has made it just too possible and has been an amazing eye-opener to all of us, that it can only be at the risk of our constitutional democracy that we allow criticism to linger on for too long. As and when it arises, because we have helped each other to be more alive to criticism directed by the judiciary towards the executive or parliament or vice versa, that might be damaging to the integrity of those institutions, it then affords us the opportunity to meet without compromising our independence and say, there is this criticism. Let's nip it in the bud and explore the most effective and efficient way of doing so. That's all I have to say on that point.
Thank you very much. I think I had said two. Mokomotsi, I think who's the second one, or else that's the last one. Doesn't have to be four. The gentleman.
Thank you, Pumla. I'm Mokomotsi Makome from Independent Media. My question is for the Chief Justice. One of the criticisms that have been leveled towards the judiciary is what is often referred to as judicial overreach, where judges are seen to be, in their judgments, veering into the political sphere or the policy-making sphere. I want to know from the Chief Justice, is this, in your view, is this a legitimate criticism to be leveled against the judiciary? Thank you.
Thank you.
Good evening, it's Kaya here from Kaya FM News. Just to get an indication from the esteemed President and the Chief Justice, I mean, some of the critics have labeled this meeting as an indication that there might be a constitutional crisis. So just to get your views on that score, and just regarding, of course, just to find out about the forum, like you said, Mr. President, that, this laid a foundation for future engagement as to, will this be done annually in terms of the engagement, or will these engagements be done as per any matter that arises? Thank you.
It's over to you, President.
Thank you. Thank you. Well, I I think it is our view that this meeting is historic. I think that tells you how much we all acknowledge how useful it has been to have this meeting after some concerns on both sides. I think there was a feeling expressed that this adds value to our democracy, because it's not like a common practice. Now in South Africa we are saying, being the three arms under one state, independent, but working for the same state, we are likely to find such concerns emerging. Being a democratic state, it fits very well that we can meet and discuss these issues, clarify the issues, dispel concerns and suspicions, so that we work from a level where we all are aware that we have got objectives in common, that we are working together. So we have actually felt from time to time, as the issues arise, we should have an opportunity to meet and talk, not just between the national executive and the judiciary, as well as the legislature. I think it adds value to our democratic system that these arms are able to talk together on issues of common concern, because we have got one objective, really, to make South Africa truly a democratic country. And therefore it is useful. That's why I think the Chief Justice was saying this has been an eye-opener. For us to meet and exchange views and raise issues in the manner in which we have done today is very useful for our democracy, not just for the sake of the institutions or the arms, but for democracy itself, that these institutions can meet and talk and help, therefore, to enhance democracy, to clarify the understanding and interpretations. So it is an important one. We did not want to institutionalize it to say we'll meet every June, every year. Not necessarily. But we thought from time to time, when need arises, it should be easy for us to meet. Some issues could be dealt with at a level where we interact with the Chief Justice. But some issues might need this kind of thing. There are issues we felt, for an example, they might need, not necessarily meeting composed in the manner in which we have today. There are issues that might need something like a seminar, just for purposes of clarifying the issues as we lead the country as these institutions. So, to me, the fact that we have accepted this and we have agreed that we need to do so is an important step to help enhance our democracy. Thank you. I think the other question is specifically for the Chief Justice. I'm not a judge. I wouldn't attempt to give judgment.
The reality, the constitutional reality is that it is the responsibility that rests on the shoulders of the judiciary to interpret the Constitution and the law. That will never change. But it would be quite arrogant of the judiciary to say, nobody who is not a judge should ever be heard to be questioning the manner in which we go about our business. By the way, it has never been our position. Our position has always been, it is the way you question that matters to us. Now, separation of powers, judicial overreach, are issues that are raised with a sufficient measure of frequency to justify or warrant a broader and deeper engagement than we have had today, and than this question and answer session could ever allow us to have. As the judiciary, we obviously don't think that we're overreaching. But you know, it is not always that you can be the best judge of yourself. So we would benefit from the views, the constructive views and criticism from other arms of the state as much as we benefit from constructive criticism from the media and the academia. And the suggestion by the President that we explore the possibility, as set out in the statement, of a seminar or a conference at which there can be free engagement, possibly with the added benefit of inviting people from comparable jurisdictions elsewhere, would help us to deal with this question properly without the judiciary looking like it is being defensive. So I restate the point. We don't think we're overreaching, but there is obviously a deep-seated concern about the manner in which we deal with separation of powers and related issues. And the profound lesson that today's meeting has provided us with is that you can only become a better person and a better institution if you open yourself up to the wisdom of other people, whether you agree with what they have to say or disagree with it. But more importantly, this concern about overreaching, this concern about separation of powers, I think to a large extent bears testimony to the vibrancy of our constitutional democracy. I think it bears testimony to the fact that everybody, the judiciary in particular, is doing what it is supposed to do. I would be worried in any proper constitutional democracy if differences are of a minor nature. I read quite a bit about comparable democracies, and there are always serious tensions between the presidency and the judiciary, the executive and the judiciary. But that is only where everybody is doing what he or she is constitutionally mandated to do, because it is bound to pinch somewhere. And when it does, it attracts reaction. So, our democracy is demonstrably healthy, hence these concerns will make it healthier as we embark on the process alluded to, either in the form of a seminar, a conference, or whatever format it may take. Constitutional crisis. We made the point on the 8th of August, I think it was, that from where the judiciary stands, there is no constitutional crisis. And I reiterate that point today. All we see is a moment for deep reflection, a moment for a brutal self-introspection, a moment for a brutal institutional introspection. None of us should allow themselves to be blinded by their own science of correctness. Open yourself up to the concerns of others, even if you may not agree with them. There may just be something to learn from that criticism. The other thing that needs to be mentioned is that of the three arms of the state, I think I meet with the executive more as represented by the president than I do with Parliament. We discuss matters of mutual interest that affects our institutions. But today's meeting and the developments that culminated in its being held have helped us to appreciate that maybe the menu should be broadened so that there is nothing of importance that require urgent attention that does not receive that attention as urgently as it deserves it. That's all I have to say.
The President and Chief Justice is a photo opportunity for the media. They are requesting a photo opportunity with yourselves and also with the Deputy Chief and the Deputy President, I think, in this area. Thank you.
I think we go there. Where do you stand? On top?
They are the experts. Yes, yes, yes.